What is a content-neutral regulation? A content-neutral regulation is a government rule that limits the time, place, or manner of speech without regard to what the speech actually says. In other words, unlike content-based restrictions, these regulations do not discriminate based on the subject matter, viewpoint, or message. Instead, they apply equally to all speakers, no matter their ideas, as long as the rule focuses on how, when, or where the speech occurs. The origins of content-neutral regulation doctrine lie in First Amendment jurisprudence of the 20th century. Courts recognize that while the government must not interfere with the free exchange of ideas, it still has a legitimate interest in regulating public spaces, preventing excessive noise, maintaining order, and ensuring public safety. To strike this balance, the Supreme Court distinguished between regulations that target the message of speech, content-based, and those that simply control the circumstances of speech, content-neutral. The legal test for content-neutral regulations is intermediate scrutiny, which is less demanding than strict scrutiny. Under this test, a law will be upheld if it meets three conditions. It serves a significant governmental interest, such as traffic control, public safety, or preserving residential peace. It is narrowly tailored to achieve that interest without burdening substantially more speech than necessary. It leaves open ample alternative channels for communication. A classic example is noise regulation. Suppose a city passes a law banning the use of loudspeakers in residential neighborhoods after 10 o'clock at night. The rule does not care whether the loudspeaker is promoting a political rally, religious event, or rock concert. Since the restriction applies to all messages equally, it is content neutral. Similarly, requiring permits for large demonstrations in public parks is generally content neutral, as long as the permitting scheme applies evenly and does not discriminate based on message. One famous case illustrating this principle is Ward Vier's Rock Against Racism, 1989. New York City required performers in Central Park concerts to use city-provided sound equipment and technicians to control noise levels. A rock music group challenged the rule as a violation of free speech. The Supreme Court upheld the regulation, reasoning that it was content neutral. The rule did not regulate the kind of music or message, only the volume, serving the legitimate interest of protecting nearby residents from excessive noise. By contrast, if a city allowed religious groups to use loudspeakers late at night but banned political groups from doing so, that would be content-based. The distinction is crucial because it determines the level of judicial scrutiny and the likelihood that the regulation will survive. Content-neutral regulations are not unlimited, however. Courts scrutinize them to ensure they do not effectively suppress speech and practice. For example, a city cannot ban all protests in all public areas at all times under the guise of public safety. That would eliminate meaningful opportunities for free expression. The requirement of ample alternative channels ensures that speakers still have real opportunities to communicate their message. A curiosity about content-neutral regulations is that they often create close cases. Sometimes a law appears neutral on its face, but has the hidden effect of burdening certain messages more heavily. Courts then must decide whether the law is truly neutral or whether it masks a content-based intent. This line between neutrality and disguised censorship keeps First Amendment litigation lively and complex. In conclusion, content-neutral regulations are rules that manage the logistics of speech, its time, place, or manner, without discriminating against the message itself. They play an important role in balancing free expression with public order, allowing cities and governments to maintain safety and livability while protecting robust debate. Unlike content-based restrictions, they are judged under intermediate scrutiny, making them more likely to survive in court so long as they are fair, tailored, and leave open alternatives for communication. Above, I leave you more videos so you can continue learning law. Remember to give us a like and subscribe.